Hello, I'm Jill Ruane, and I represent juveniles and adults at my law firm, Ruane Attorneys. Today we are going to talk about social host issues, because as your children enter high school, alcohol becomes a likely source of problems. Alcohol use by underage drinkers is one of the more common problems when you host any party. It is no longer acceptable to allow underage party guests to consume liquor. The potential liability is too great. If you serve alcohol to your underage party guests, you face not only criminal charges, but you've exposed yourself to liability for civil lawsuits and money damages for any resulting harm they caused. Rule number 1, no underage drinking at your party. The law is very clear. No one under the age of 21 can possess or consume alcohol. You can't serve alcohol to underage minors. You can't allow them to possess alcohol, yours or their own. They might try to sneak some. If you host a party that your teenagers attend, you must follow the law and not condone underage alcohol drinking. There can't be any exceptions to this rule. There are severe criminal and civil penalties that could be imposed if you are caught knowingly breaking the law. Too many teenagers have been hurt or been involved in fatal accidents because of underage drinking at parties. Police and prosecutors are really aggressive in prosecuting social host liability cases because they're looking to set an example for the entire community. Any social host caught knowingly serving alcohol to an underage drinker will be charged with the crime of sale or delivery to minors, which is a Class E criminal felony. This crime can carry a penalty of up to 18 months in jail and a fine of up to $3,500. Let's take an example. Say Jim hosts a prom party for his son and 5 friends. All are high school students, all are underage minors. Now Jim serves them champagne because they are driving, after all, it's prom, they're taking a limo. Jim figures that since no one is driving themselves, there's no harm in letting the kids try a little alcohol as a part of their prom celebration. Did Jim break the law? Yes. Jim has violated a clear law and he has exposed himself and the kids to arrest and prosecution. FYI, the kids also broke the law here when they possessed and when they consumed the alcohol. Jim directly and purposefully served alcohol to minors. There are no exceptions to this rule because it's prom, graduation, another event. There is no exception. The kids are not driving themselves. Doesn't matter. The party guests are underage 21. They cannot be served alcohol. They cannot legally drink it, and they cannot legally possess it. In situations where underage drinkers were under the age of 16, this crime is magnified because of the age of the children involved. In this kind of case, the social host could also be charged with an additional crime called committing risk of injury to a minor. This criminal charge is a Class C felony. That means it carries a maximum penalty of up to 10 years in prison and a fine of up to $10,000. It's no joke. The law doesn't just penalize the social host. The kids will get in trouble too if they're caught with alcohol. Underage drinkers face strict penalties under the law. Any underage minor caught either in possession of or consuming alcohol will be prosecuted in court. The underage teenager will receive an infraction ticket from the police officer. For a first offense, they will face a court fine, usually less than $150. But the police will notify the DMV, and the DMV will in turn suspend their driver's license for 30 days. In addition, the high school can take action against them when they return to school. The teens could face administrative sanctions from their school, and they could be kicked off of activities or even sports teams. Let's take another example. Say Morgan is a 17-year-old high school student athlete. She goes to a winter break party at a friend's house. Beer is available at the party, and Morgan decides to try some. Right after Morgan pours herself a cup of beer from the keg, but before she actually drinks any alcohol, the police raid the party. Noise complaint from those pesky neighbors. And they catch Morgan holding a full cup of beer. Now, remember, Morgan never drank any beer. She was simply caught just holding the cup. Is Morgan in trouble? Yes. Morgan is under 21. She's not allowed to possess alcohol. She can't even hold a beer cup in her hand. Morgan has broken the law. She will be charged in court. Her driver's license will be suspended, and she'll likely be suspended from school and the sports team too, because remember, she's an athlete. These penalties may seem overly harsh, but there have simply been too many teenagers harmed by underage drinking. The law isn't just concerned with adults that knowingly serve alcohol to minors. The law addresses situations where the adults are willfully blind to underage drinking as well. Let's take another example. Say Martha hosts an annual end of the summer barbecue at her home. The teenagers usually retreat to the basement to hang out beyond direct adult supervision. Martha keeps beer for the party stored in her basement refrigerator. She knows that her underage guests sneak beer at the party, and while she doesn't directly serve them alcohol, she condones their sneaky behavior so long as they don't cause any trouble and they aren't obvious about it. Martha turns a blind eye to the underage drinking at her barbecue. Since Martha didn't directly serve beer to the kids, is this okay? No. Martha has committed a crime. The law says any social host who knows or should have known that underage drinkers were in possession of alcohol, or who learned about alcohol possession by underage drinkers but did not do anything in response, will be charged with the crime of permitting a minor to illegally possess alcohol. Now, this is a Class A misdemeanor. That means it carries a maximum of up to 1 year in prison and/or a fine of up to $2,000. Under the law, you can even be prosecuted for underage drinking when your teenager throws their own party and you aren't home. If your teen threw a party where alcohol was served and you knew about it, or probably should have known about it based on their past conduct, and the police are called, you will be arrested and charged with a crime if alcohol is involved. Furthermore, if someone was hurt at your party, you could be subjected to a civil lawsuit. You could lose your house, your savings. Your teenagers will also be held responsible as social hosts under the Connecticut law. Consider this situation. James and Sandy leave their home for a weekend golf vacation in Florida. But before they leave, they give their teenage daughter Caroline permission to throw a small party. They don't lock up their alcohol before they leave for vacation. They never bother to check on Caroline or the party. Caroline invites several friends to her party, but many other teens end up crashing. The guests immediately start to drink all of James and Sandy's alcohol. One of the party crashers, a fellow high school student named Mark, drinks several beers and decides he's going to leave and go home. But on his way out of the driveway, Mark backs into another car, causing damage. Now the cops are called. Are James and Sandy responsible for the party and any of the damages? Yes, James and Sandy did not directly provide alcohol to any underage drinkers. However, they did not act responsibly with respect to this party. Under the law, James and Sandy acted recklessly. They knew about the party. In fact, they gave Caroline permission to throw the party, but they failed to monitor the party and they never secured their own alcohol. They failed to make reasonable efforts to stop or block teenagers from accessing their alcohol. James and Sandy are also responsible for Mark's conduct. At a minimum, James and Sandy face a Class A misdemeanor or criminal charge. Remember, that carries up to 1 year in prison and/or a $2,000 fine. But they can also be exposed to civil liability for money damages due to the property damage that Mark caused to the other car. Caroline faces charges too. She provided alcohol to minors and engaged in underage drinking herself. Caroline's and any other party guest's license will be suspended by the DMV, and certainly Mark will face penalties under the law for his conduct, which includes underage drinking penalties, drunk driving charges, and a civil lawsuit for the property damage he caused to the other car. Now, what can you do to protect yourself? The best course is to enforce a strict no party rule when you aren't home, and to constantly monitor your teenager. If the party never takes place, you're not exposed. Unfortunately, your teenager and their friends may not cooperate. They may view your vacation as an opportunity that is too good to pass up. As a responsible parent, you must prepare for this possibility. So to avoid certain disaster when your teenager hosts a party for their friends, we suggest you consider some of the following guidelines. Require your teen to tell you if they intend to invite any friends over while you're away. Make sure your alcohol is not accessible to any teen on your property. Designate certain areas of your home as guest areas to control access to your home. Limit the number of guests and enforce a no crashing rule to restrict party size. Do not permit any party guests to leave and then return to your house. And constantly monitor your teens when you are away by calling, having an adult come and check on them, or even using video monitoring. We know that some of these recommendations may seem harsh, and your own teenagers will undoubtedly accuse you of not trusting them or invading their privacy. But you need to realize that the consequences of them hosting a party are severe under the law. It's your home, and you have the right to set these rules. You must protect yourself, your teen, and their party guests from impulsive and irresponsible behavior regarding alcohol use. If you fail to do so, and your family will face terrible consequences. Am I responsible if my teen steals my alcohol without my knowledge or consent? No. Unless you turned a blind eye to this situation, you will not be held responsible if your teenager steals and smuggles your alcohol to one of their friends' parties. Your son or daughter stole your alcohol without your knowledge. You did not violate the law by directly providing alcohol to your teen or underage minors. Your son or daughter stole your alcohol without your knowledge. You did not violate the law by directly providing alcohol to your teen or any other underage drinker. You did not act as a social host for a party thrown by your own teen. You are not responsible under either of these laws against underage drinking. Maybe you should have locked away your alcohol to prevent your teenager from being able to access it. Well, there is no legal requirement for you to do so, unless you have some prior knowledge that your teenager might try to take that alcohol without your permission, and then you fail to do anything in response to this kind of behavior, then you could be responsible. But if you didn't know, then you're not responsible. Of course, once you realize that your alcohol's been taken, then you must immediately reach out to the host parent and tell them that your teenager might be in possession of alcohol. Also, besides contacting the other parent, you need to make reasonable efforts to get your alcohol back from your teen. It's probably time to take a drive over to the other parent's house. And keep in mind that your teenager cannot even legally possess alcohol. They are in complete violation of the law, and they face both an infraction penalty of a money fine and suspension of their driver's license. If they were caught while driving, then they face a longer suspension period. The infraction penalties increase for second and subsequent offenses. Think about this. You let your teenager Jennifer borrow your car, but you forgot you left an unopened bottle of wine in the back seat. Jennifer is stopped by the police for speeding, and when the police officer approaches the car, he sees the bottle of wine on the back seat. It's still sealed. Jennifer never even looked in the back seat. She has no idea that that bottle of wine is there. Is Jennifer in trouble? Yes. It is entirely illegal for anyone under the age of 21 years old to possess alcohol. This includes having an unopened alcoholic bottle in a car or a can that's unopened. They face a monetary infraction and a mandatory driver's license suspension. It doesn't matter that your teen didn't even know the wine was there or that the wine bottle wasn't even opened. Another area that the law addresses is when teenagers use falsehoods to try to buy alcohol. Unlike when you were a teen or in college, our laws now provide very strict penalties for underage drinkers who use false statements or fake IDs to obtain alcohol. If your teenager uses a fake ID or tries to use another person's driver's license to buy alcohol, they face 30 days in jail with a fine between $200 and $500, and their driver's license will be suspended for 150 days. If your teenager makes a false statement to try to buy alcohol, they face a fine between $200 and $500. For example, let's say Rob, age 17, was asked to bring some alcohol to his friend's party. Knowing that he wasn't old enough to legally buy alcohol, Rob snuck his older brother Tom's ID card. Tom's 22 years old. Rob tried using Tom's ID in the local package store to buy some beer. Bill, the store clerk, quickly saw that Rob's appearance did not match Tom's picture on the photo ID. Bill refused to sell to Rob and called the police. What could happen to Rob in this situation? It is illegal for any underage minor to misrepresent his or her age by either using a fake ID or someone else's ID card. Rob faces criminal charges, possible jail time, fines, and a suspension of his own driver's license. As a society, we recognize that underage drinking is harmful to minors. In response, the law enforces restrictions against teens from possessing alcohol. The law recognizes that teenagers might steal, lie about their ages, or even use fake IDs in an effort to procure alcohol. As a parent, you need to make reasonable efforts to block your underage teenagers' attempts to obtain alcohol. If you try, even if you're not fully successful in your attempts, you've protected yourself. Once again, I'm attorney Jill Ruane. Thank you for listening. If you have any other questions, you can also check out our website at ruaneattorneys.com. You could even check out our ebook, A Parent's Guide to Teenagers and Alcohol Laws, by texting ebook, EBOOK, to 203-925-9200, and we'll send you the link for that book. Thanks again.